advocates come and say that this was a petition for divorce, how come judicial
Judicial
order,
separation.
without indicating any reason why the court thought it expedient in the facts of the case to pass an order for judicial separation?
My lord.
You know, you understand the reason why judicial separation is ordered even in a proceeding for divorce.
Yes, my lords.
This is to give you some cooling
some
off period so that
space
you
and
can
time.
get back.
Yes, my lords.
The
So that a
relationship still
reconciliation,
subsists.
if at all a reconciliation is
So
possible, that can be arrived
therefore,
at.
13(1)(a) would not come to your avail for the reason that there has not been any cohabitation, because you have not been cohabiting for whatever reason for the last 7-10 years,
Lordships.
and
my lord.
therefore, could you not question? And these are the issues which you should have thought of before.
My
Could you
lords.
not have questioned the wisdom of the court in passing an order of decree of judicial separation
Exactly.
in a case of this kind? तो वो सब
Exactly.
बहस करिए ना, आप
Ex-
handmaid of justice क्या बहस?
Exactly, my lords, basically, lords, what I was, since I was looking through these judgments, this was only to bring out this point that even
Now
because
you do
my
one
lord
thing.
had
Now you
suggested
do-
to
now-
file a petition
Now
there.
you do one thing. You have been taken by surprise because we have abandoned our reservation with respect to 13(1)(a).
Lords,
Now you have
I
to
was
argue-
trying to,
Just a
to
minute,
convince my
please,
lords that
please
even in
hear
an
the-
appellate proceeding,
Please hear out the court.
Lordships.
You will turn out to be. I mean, it will turn out to be beneficial for both
my,
the parties.
my lords,
Now you address this court on the issue as has been decided by the Supreme Court in Dastane versus Dastane
cruelty,
and Samar Ghosh versus
Jaya
Jaya
Ghosh,
Ghosh.
my lords.
इसको देखकर आइए, इस पर बहस करना हो तो करिए, और 13(a) अब नहीं चलेगा.
Although जो 13(1)(a) का option हमको,
no.
it's not getting
That argument
closed for
means
me.
Therefore, you address the court
My
that
lords.
the court below was not justified in passing an order of judicial separation,
Lordships,
and he should
lords.
have passed an order on the merits, whether rejecting the petition or
Lords.
allowing the petition.
Lords, my lords. My
वो
lords.
बहस करना है, ये सब पर कहाँ पा रही हैं?
नहीं, हुजूर, चूंकि ये इशू उठ गया था कि वहाँ पे तो I was trying to lords
You
only
will not succeed
preparing
there.
myself,
The
lords,
reason
that
is, therefore, in the starting I said that
lordships.
your approach, if you approach the court below under 13(a), capital A1, not 1(a),
One capital A, yes, my lords.
13(a)(1),
My lords.
then perhaps you would meet a stiffer resistance in view of the provisions contained in section 23(1).
23(1).
23(1).
Yes, my lords. That's 23(1). This is decree in
I
proceedings.
think it's 23, yes. 23(1). Decree in proceedings, yes.
Decree in proceedings.
Yes.
In any proceeding under this Act, whether defended or not, if the court is satisfied that A. Any of the grounds for granting relief exists and the petitioner, except in cases where the relief is sought by him on the grounds specified in subclause A, subclause B or subclause C of clause 2 of section 5, is not in any way taking advantage of his or her own wrong or disability for the purpose of such
Now
relief.
you get stuck
My
up
lord
here.
is My lord is hinting at that, this very provision, that
This is
I
the-
should not be responsible for this.
Yes.
Yes, my
So
lords,
therefore,
I get the point. my
Therefore,
lords.
your wife, your adversary would be perfectly entitled to say that the purpose was not this when the court had passed an order.
My lords,
Because you had to approach.
lordships.
And unless you say that you have made up your mind to start cohabitation, to end all this dispute, perhaps you will not be able to take advantage of 1 year non-cohabitation after the decree in judicial separation.
My lords,
So therefore, that is a useless exercise for you to undergo, right?
my lords.
Because you have not made any effort. This is what I can presume from
Lordships.
how you are arguing.
Lordships,
So
my lord,
therefore-
both the parties, my lords. My lords, I had
Therefore
made
you-
one more submission on the last
Therefore,
occasion.
We are prima facie on going through the judgment. We are not convinced that the judgment is bad because there is no evidence whatsoever of you facing any injurious kind of a circumstance if you stay with your wife.
Or the disease is not curable, if my lord is going on that. Lords, one more thing which
I am
I'd
not going.
I'd
This is the position of law as established
Lordships,
in
Lord.
date.
Lords, one more thing which I pointed out last time also, Lord, that in the judgment, Lords, my Lord had noticed that I had filed a suit for divorce, and there was a counter claim under section
Counter claim is
23A.
all right. Restitution of conjugal rights, that has not been allowed.
That was rejected, and Lords, no steps have been taken. Lords, they have not appealed against that order. That also shows the intention of the respondent wife also.
Therefore, 13(a)(1) is out of question now. Right? 13(1)(a) is out of question. Therefore, we have to decide it only on the basis of the materials which were there before the court and the ground that you took and the reason that you took. Yes? What is
Lordship.
what is your idea? What is your instruction?
Lordship.
Cohabitation has not happened for last 10
Lordship,
years.
Lordship.
15 years.
For that respondent is not responsible, Your Lordship. For that appellant is responsible. With regard to that aspect, Your Lordship, on previous occasions, several times the conciliations was made between the parties either in the court below or on before the Honorable High Court. On previous occasion when this appeal has been filed by the appellant, thereafter the Honorable Court sent this matter to the mediation center with regard to the consideration of this fact. Even though the husband is adamant to live the conjugal life with the respondent, Your Lordship. Subsequently, such arable breakdown has been made between the parties, Your Lordship. With regard to that aspect, the respondent is not responsible. More so, Your Lordship, here our learned filed this appeal before the Honorable Court only against the order which has been passed by the learned Principal Judge Family Court Darbhanga, in which the judicial separation has been given after dismissing this fact that the appellant is unable to establish the allegation against the respondents which has been assigned in the matrimonial case, Your Lordship.
So what is the proposition that you are advancing? That the judgment is all right.
Lordship.
All right. So what happens to the step?
Lordship,
Just a minute.
Lordship, one child is
Chap,
also there,
सुनिएगा सही तो।
and the respondent is living want to live with the appellant, Your Lordship.
Are we talking about alimony now? No, we are not. We will think about it over the process. Now, what would be the status of marriage if irretrievable breakdown has happened and there has not been any cohabitation? All fault on the husband.
Lordship.
Now, judicial separation, this status of marriage, because the marriage has not been dissolved. Now, this will continue for how long? This is the question that you need to answer, which she is also required to answer.
Lordship.
There is because the only thing which the husband is facing now, no commitment so far as matrimonial obligations are concerned.
Lordship.
Judicial separation. Therefore, under law, the husband is not bound to cohabit, right? Because he can ignore those matrimonial obligations. Permanent alimony, the alimony which the court has ordered, that must be being paid to you. Now, therefore, this situation cannot continue forever, where the parties don't have the option of marrying or doing whatever. The marriage remains. So this has to go someday. Now, what do you have to suggest for this? Irretrievable breakdown, all right. Suppose we pass an order that this judgment of the court below for judicial separation is bad. In fact, it should have been rejected. Then what happens? You stay under the same roof, under the orders of the court. Cohabitation will not automatically begin, right? Therefore, you have to address yourself to that aspect of the matter. Is anything possible now?
Lordship, as per the Hindu mythology, marriage is a sacrament, Your Lordship. It is not contract.
वो सब बहस अगर करेंगे,
when
क्या नाम है आपका?
Lordship,
क्या नाम है आपका?
Sanjeev Kumar Jha.
Mr. Sanjeev Kumar Jha, वो sacrament and contract ये सब बहस अब छोड़ दिए.
Lordship.
When I have spoken so much, you need not remind the court that it is a sacrament and therefore straight away not divorce. Some window and ये सब बहस करना बेकार, पुरानी बातें बहस करते हैं आप.
And so far.
आप पहले सुने तो सही मैं क्या कर रहा हूँ.
Lordship.
Sacrament वाली बहस withdraw करिए, वो सब we are aware of all that. Huh?
Lordship.
That is too well known and it's a kind of cliche now, which we do not consider it to be important while discussing, while dealing with this case. Now, I have told you the way. Suppose we pass an order that in fact the court below was wrong in granting judicial separation. There was no expectation of the parties to resume cohabitation, and therefore either the application for divorce should have been allowed or rejected. We can do that, right? Is it going to fetch you any relief? Tell us.
Lordship,
we are inclined to be fair to both the sides. We are inclined. We find that the order of judicial separation is bad in this circumstance. The court below has not applied his mind. If he found that the pretext of your illness, your schizophrenia could not be proved as your application, but that could not have been done because your application under section 9 was dismissed. The counter claim was dismissed, right? And judicial separation here. So if nothing is happening, it would be only in the interest of justice that a decree of divorce be passed and you be granted permanent alimony. There are some technical constraints in accepting the argument of both of you. Prima facie we are finding that the court below was not justified in rejecting your prayer for restitution of conjugal rights as a counter claim, and rejecting the husband's claim of divorce, and then granting judicial separation without assigning any reason. No reason is required to be assigned under 25. Under what is that?
Section 10.
Under section.
No.
13.
No, section 10 they can pass an order for judicial separation can be. And 13, section 13(1).
13(1).
Section 13 notes 1A.
Section 13.
13A, 13 capital A. That's an alternative relief in divorce proceedings.
So therefore no reason was required to be passed, but we don't find any reason to be there, even sub silentio. There is no reason whatsoever. Cohabitation is denied and judicial separation. Now this kind of
Not the reason, the section itself says not if it considers it just to do. So therefore some reason has to be assigned.
It could be inferred from the judgment. So therefore if there is no cohabitation on that ground, and the reason appears to be that does not appear to be any reason to us, for the reason that otherwise the court would have allowed your counterclaim. Therefore the court finds that as on date there is situation is not conducive for directing for a cohabitation. So this situation would continue for how long?
My humble submission before the honorable court, it would be better for the.
No, we are therefore
Lord.
we are. MS Srivastava will be now required to argue only on the merits of the case. Now we have told you what we have found from the judgment. Now you have to tell us whether the court was right in rejecting your claim, your claim that your wife is schizophrenic and that you possibly cannot live with her with this kind of illness.
Its cruelty was also one of the grounds.
Cruelty arising out
But that
of
could not be
this.
established.
Not, not,
But yeah.
not only that, not there
जो
are
कर रहे हैं उसको समझने का प्रयास करिए. जो घर से पढ़ कर आए हैं वही बोलना जरूरी नहीं है. You must respond to the observations of the court. जो सामने में जो बात आ रही है उसको रिस्पॉन्ड करिए. दैट इज कॉल्ड एडवोकेसी. जो तैयार करके लाए हैं वो तो आप तैयार करके लाए हैं. what is emerging from the discussion, you should respond to that. But yes.
Lord's cruelty on grounds of her behavior,
no,
her allegations of extramarital affairs.
No,
all those things.
This is your consistent case that this kind of behavior emanates from her illness. So therefore you have not been able to prove anything in your favor. That is what the court says. You find out, you tell us how the court has gone wrong.
Lords, I'll demonstrate
today,
Lords, because
today.
Yes, Lords.
If not, we give you only time till tomorrow. Read Dastane versus Dastane,
Lords,
and read Jaya Ghosh versus
Samar Ghosh. Lords, I've
Jaya
seen
Ghosh
that.
versus Samar Ghosh would help you,
my Lords,
look at an anthology of the judgments of the Supreme Court,
my Lords,
with respect to cruelty arising out of schizophrenia. Right?
Lords,
and then you say whether the court was right or court was wrong. So tomorrow, with respect to the evidence, now you have seen this is what has transpired between us.
My Lords.
So
Lords,
counter claim, rejection of the counter claim was wrong. If the court has rejected your plea of divorce,
then it
but on the same ground has given a judicial separation, then it was with the intent that you shall make efforts for cohabitation. That you have not done.
Although
so
the provision doesn't say so. Section 10 itself says so, that it is not obligatory on the.
But the way, that's all right. But the manner in which the counter claim was rejected gives an impression that this was the mindset of the court. Otherwise, the order would have been different
Lordship, the court also understood that maybe it was not possible considering the long
at that time.
at that
So
time.
where is your conduct now? Would you be ready? Forget about the conduct. Would you be ready to give it a try?
So after 15 years of
So that's all right.
separation.
So therefore
that's-
we decide. Therefore we decide whether the order is correct or not. If it is correct, all right. Merely on the ground of non-cohabitation, orchestrated at your end, could you get a degree of divorce? And the reason the primary reason is illness. There is no evidence of that.
That is the primary reason. Although
So
Lord, some
therefore this
prescriptions
order
have been
goes-
some prescriptions have been brought, but the
Therefore
doctor has
this-
not been examined. Lords,
Therefore,
I
this order-
agreed.
Schizophrenia, everybody is suffering from bipolar schizophrenia. Now today is the day when you would appreciate if in between husband and wife, so there is always a dispute of lack of a space, and that's because of some schizophrenic approach of either of the spouses.
My lords.
So therefore, unless you pitch in evidence, you have not done that. So we don't find this judgment to be apt.
Lords, I'll try to show
It's
whatever the material
absolutely-
is available
it's
before me, Lords.
absolutely
I'll try
we
my
quite
best.
see that you have not cohabited with your wife, and it doesn't seem to be likely in near future. So
Lordship,
why
sir.
keep you bound with this,
My lords.
especially when there is a provision for divorce on this ground?
Lordship,
But
sir.
you have not been able to demonstrate that. That's our difficulty.
Lords, although this was one Patna High Court division bench judgment, Lords, I understand that irretrievable breakdown of marriage is not to be used as a ground for divorce, unless it is Article 142. But yet, Lords, one judgment of Patna High Court division bench I could find, Lords, considering all these, a long stint of separation, and considering that the marriage was not going any further, Lords, the application was allowed. So I have that one judgment with me, Lords.